to a brand new episode of Law and Batting Order. I'm your host, Tony Iliakostas. Here are some quick hits from the past few weeks. A lot has happened since the last episode of Law and Batting Order, and I would be remiss to not give a shout out to the Louisville Cardinals, who played the best college basketball we have seen in years. The Cardinals were doing very well up until the Elite Eight, when their best player Kevin Ware went down with a gruesome leg injury. The injury was so severe that TV stations couldn't air the replay of the injury. But the Cardinals were motivated as they went on to beat Duke, Wichita State, and Michigan and claimed the NCAA Men's Basketball Championship. Congrats to the Cardinals on a great tournament run, and we wish Kevin Ware a smooth and speedy recovery. Speaking of basketball, the NBA playoffs are upon us, and for basketball fans like myself, Christmas is here. We have a slew of competitive teams in this year's playoffs who are bound to make some noise. Will the Heat win a second NBA championship? Can Carmelo Anthony and the Knicks soar to the NBA Finals? Will Kevin Durant and the Thunder redeem themselves and claim the ultimate prize in the end? These are all questions that beg to be answered. At the time this episode was filmed, the NBA playoffs have already kicked off, and hopefully this will be one of the best playoffs we'll see in a long time. Switching back to college basketball, as I said, a lot has happened since the last episode of Labo, and recently a massive scandal was revealed regarding Rutgers men's basketball coach Mike Rice. ESPN's Outside the Lines obtained video from former Rutgers employee Eric Murdoch of Mike Rice intentionally throwing balls at players, pushing and abusing players, and calling them homophobic slurs and other profanity-laced phrases. The video led to much criticism by sports media personalities and even New Jersey Governor Chris Christie. Ultimately, Rutgers made the decision of firing Mike Rice along with Rutgers athletic director Tim Pernetti. The litigation that will come from this is unimaginable, but at least Rutgers took the right steps in putting an end to Rice's bullying. Today's Order in the Court will pick up on part 2 of my discussion of Michael Kidd-Gilchrist's photo being used by Nike for promotional purposes during their March Madness campaign. If you need a refresh regarding this ad campaign or want to watch the last episode of Labo, you can click the annotation on the right or the link below this video. As I said in the last episode, the situation involving Michael Kidd-Gilchrist's photo being used as a stock photo by Nike has some legal implications under the recent OBannon vs. NCAA litigation. Remember that the photo of Michael Kidd-Gilchrist was taken when he was a member of the University of Kentucky Wildcats in 2012. However, Michael Kidd-Gilchrist couldn't make any money as a college player from that photo as per NCAA rules. Fast forward to 2013, where Michael Kidd-Gilchrist is in the NBA, yet the NCAA and Nike are using his likeness to make money. How is this possible? How is it that the NCAA and Nike can make money using Kidd-Gilchrist's photo, yet Michael Kidd-Gilchrist isn't getting a dime? A lot of these questions are answered in what we know from the pending OBannon litigation, and in today's episode, I'll discuss how OBannon vs. NCAA applies in this situation. OBannon vs. NCAA was a case that was started by former NCAA athlete and champion Ed O'Bannon. O'Bannon led the UCLA Bruins men's basketball team to a championship in 1995 and even had his number retired by UCLA. He played in the NBA and internationally from 1995 to 2004. While in college, O'Bannon, much like every NCAA athlete, had to sign a form, specifically Form OA-3A, which states that an athlete relinquishes rights to the use of his own images and authorizes the NCAA and other third parties associated with the NCAA to use a player's likeness or image to promote NCAA championships along with other NCAA events and programs. The NCAA bylaws have the same rule in Article 12.5.1.1, stating the following: a member institution or recognized entity thereof, a member conference, or a non-institutional charitable, educational, or nonprofit agency may use a student-athlete's name, picture, or appearance to support its charitable or educational activities or to support activities considered incidental to the student-athlete's participation in intercollegiate athletics, provided the following conditions are met. In relevant part, the student-athlete and an authorized representative of the charitable, educational, or nonprofit agency sign a release statement ensuring that the student-athlete's name, image, or appearance is used in a manner consistent with the requirements of this section. In 2009, Ed O'Bannon filed a lawsuit against the NCAA for disseminating his likeness and the likeness of other former NCAA athletes to EA Sports as part of their video game production featuring legendary NCAA men's basketball teams. He's claiming that the NCAA is making money off OBannon's likeness and the likeness of other former student athletes, all while the former student athletes are not getting a dime. Thus, OBannon is suing the NCAA on the basis that the NCAA is acting in violation of the Sherman Antitrust Act. In the most recent opinion heard in the Northern District of California, the court struck down the NCAA's motion to dismiss, stating that OBannon and other former NCAA athletes had valid arguments to bring an antitrust claim against the NCAA. The court has not determined a winner in this case yet, and we won't expect to see a winner until a few months or perhaps a year from now. In light of what we do know from OBannon and applying it to the Michael Kidd-Gilchrist case, it seems clear that Michael Kidd-Gilchrist has a legitimate claim against Nike and the NCAA. Unless Michael Kidd-Gilchrist endorses Nike and is getting paid from Nike, he can argue that his image and likeness are being used improperly. He has already left the NCAA and can argue that he is entitled to a certain cut of profit that the NCAA and Nike earn from these ads portraying his image. His claim could even be stronger if he argues that Nike is improperly superimposing his image to promote other schools' runs in the NCAA basketball tournament. But as I said, OBannon is still pending litigation, so we still have to wait for a winner. But from what we do know so far, OBannon directly correlates to the situation involving Michael Kidd-Gilchrist's photo. Before I wrap up today's episode, I would be doing myself a disservice if I didn't comment on the tragedies we experienced earlier this week at the Boston Marathon. While a suspect has been taken into custody, we should never forget those who lost their lives or suffered injuries as a result of this abhorrent act of terrorism. We should also not forget to honor the brave first responders who put their lives on the line to help those in need. So what can you do to help? You can visit onefundboston.org and make a donation. Also, a sports law friend of mine, Caitlin Kashuda, is running in honor of the victims of this senseless tragedy. For more info about what she's doing, be sure to click the link below this video. And of course, Boston, be strong. Anyway, that's the show. Leave all your comments down below, and be sure to visit Law and Batting Order at lawandbattingorder.com, as well as on Facebook and Twitter. Take care, guys.